Disclaimer: the information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you to consult with an attorney. Hello, welcome to the opening statements section of the University of La Verne Justice Center website. Glad to have you. At this point in time, a jury has been selected and it is now time for trial to begin. The opening statement takes place in the beginning of the trial. The party with the burden of proof, the one who brought the action to court, gives their opening statement first. Once the prosecution is finished, the defense follows with its opening statement. After the opening statements have been recited, witnesses and evidence are examined by both parties. The purpose of opening statements for both sides is to give the jury some information about the case, only using facts that will be proven in court and supported by evidence. They are not to be argumentative. This step is important to preface what the jury is going to be hearing and seeing in court so that they are prepared for the evidence that is going to be presented. Opening statements are not required. However, if you choose to skip this step, the jury will not know what evidence to expect or hear from your side. This can hinder the jury's understanding of the material being presented. For your opening statement, you want to create a factual statement that is going to foreshadow the evidence that the jury is going to be seeing and hearing during the trial. You want to prepare the jury so that they have a better understanding of the case when it is presented. The opening statement should range from 10 to 30 minutes long. The parties involved in a trial include the prosecution, the defense, the judge, and the jury. The opening statements take place at the beginning of a trial. Through opening statements, each party informs the jury about what evidence they will present and what the evidence will prove. The opening statements allow the lawyers to present their positions to the jury prior to the introduction of the evidence. The trial begins with the opening statement of the plaintiff, whose objective is to prove its case in order to be successful. The defense lawyer then follows with their opening statement. Either lawyer may choose not to present an opening statement. There are different parts that make up a successful opening statement. Opening statements should include a hook, a theory or theme, a summary of facts, a summary of evidence, a summary of witness testimony, an explanation of law, a request, and a conclusion. This has been an overview of the opening statements section of the law. On behalf of the University of La Verne Justice Center, we thank you for your time and hope this information is helpful in your legal matter.